The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. And welcome. We have three cases that, and welcome to the students from the University of Iowa Law School as well. We have three cases that will be submitted this morning. Those cases are State of Iowa versus Noah Crooks. Second case is Tina Elizabeth Lee versus State of Iowa. And the third case is Shamar Shams versus Sonia Hassan. That last case is now submitted to the court without oral argument, and we will hear the arguments first in State versus Crooks. Ms. Lucey.
Thank you. Good morning. May it please the court. For those of you watching, I am Martha Lucey. I'm with the State Appellate Defender's Office, and I'm representing Noah Crooks. Noah was 13 years old on the day that he shot and killed his mother. Subjecting a 13-year-old to adult prosecution and sentence is not authorized by the 2011 code. It is also a violation of Article 1, Section 17 of the Iowa Constitution. As I said, Noah was 13 years old. The state filed a motion to waive him to adult court for prosecution as a youthful offender. The 2011 statute at issue here provided that a youthful offender was 15 or younger and had specified offenses, which included forcible felonies. A traditional waiver in the 2011 code and the current code was for 14 and over. The question becomes, is the statute ambiguous, and does it allow a 13-year-old to be tried in an adult court? And I want to start with youthful offender is an adult court. There is not a separate court called youthful offender. It is a program within the district court, and just like a drug court is. So it is adult court. That's the first thing I'd like to point out.
All right, but the statute, as you know, I mean, it says 15 or younger. The second tier of the statute, if you will. I mean, the first tier says 14 and older, and then what is it? Section 45(7)A, I think. And I'm sorry if I have my alphabet wrong, but the second tier says 15 and younger. I think your interpretation is that means 15 and younger, but there's a 14-year-old floor. But of course, the statute doesn't say that. So why wouldn't the legislature have just said, well, if you're between 14 and 15, which is kind of the substance of your argument? I mean, I'm struggling with this language, and I'd like your help.
Okay, and if you compare it to the traditional waiver, it says 14 and over. It doesn't set a ceiling either. We know from the rest of the code that the ceiling is 18. You don't need to waive anybody over the age of 18. So when you look at all of the statute, all of Chapter 232 together, it does question whether or not the statute means birth to 15 or if it means 14 and 15. If we are going to say that you cannot try and convict and punish a child in adult court under a traditional waiver until they're 14, but we're going to allow a 2-year-old, I know that's ridiculous, but a small child to be punished in adult court as a youthful offender where the outcome is going to be the same thing. Did the legislature intend that?
Can you tell us how in general terms, how youthful offenders are treated differently from those 14 or 15 who are waived into adult court?
About the only way that they are treated differently is that upon conviction, their case is transferred back to the juvenile court for disposition. The initial disposition term is till the age of 18, and then at 18, they go back to district court for either further sentencing or whatever. Now, we have to recognize that at the time Noah was convicted, it's much different landscape as far as juvenile sentencing than what we have now, or even once he was sentenced at 18. But the initial disposition is till he's 18 in juvenile court. But if you compare a child who is 14, say the same thing, convicted of murder second, is, you know, sentenced in adult court. He gets a sentence of 50 years, maybe no more minimums now, but he's going to be held in custody. The question then becomes, is it going to be held by DOC? And I would say the norm is that. But there are certainly circumstances where DOC says, you know, we don't want this small child in adult custody. And they do a 28E agreement, and he's held at the training school till he's 18. So, I mean, there is some differences, but the ultimate penalty is really no different because he's still subject to adult jurisdiction at 18.
But it
Your
all seems, but it all seems to me that that's a logical and reasonable way of handling the situation that we're talking about through juvenile court. There's nothing, to me, illogical about that. I think that the child under these circumstances gets all the benefits of having the juvenile court attempt rehabilitation, and then we reevaluate at 18. What's wrong with that process?
What's wrong with that process is that then this 13-year-old, who was 13, goes back into adult court and is viewed by the adult court as this now 18-year-old adult, and the court says, you killed your mom. I don't think we're ready to let you go. It's almost like what this court did in MMC, where they
But
said...
isn't that going to happen with anyone in the similar circumstance? All this does is, to me, it just provides a mechanism, or a better mechanism than what we're dealing with now with juvenile sentences, where you're trying to figure out whether a 16 or 17-year-old that's convicted of a murder second, let's say, you have to go through the process of determining whether or not he or she ought to be released from custody. I'm not getting why that's a problem.
I think that we're left with the same problem at 18 as we are with kids who start out being sentenced at 18 or 17. We're still stuck with that idea of how is this child going to mature?
Well, what would be the district court's options
For a youthful offender or...
at 18?
At 18, the statute, and that was in a place at the time, and I think we need to deal with a new statute of the 2016 statute, was that, one, he could be discharged. Two, he could be sentenced to prison, which he was. Three, he could receive or continue his deferred sentence, which would allow probation, residential facility.
So he would not be treated as an adult because those options would not exist for adult offenders.
It would be for people who were originally convicted in adult court, yes. It would be for juveniles. It would be similar now to what, if that 16-year-old with a direct file has. Similar, except, well, trying to think whether an adult now or a 16-year-old
Well,
can
if
get
you're
a deferred
prosecuted
judgment.
if a 16-year-old is prosecuted as an adult, that juvenile is not going to be brought into court again at the age of 18 to have a sentence reworked.
No.
So the youthful offender program offers different options at age 18 than would be available for children that are waived into adult court and to be prosecuted as adults.
A traditional waiver, yes. But I still don't think that settles the argument of whether 15 and under means under the age of 14. I think that there are certainly some benefits to the youthful offender program, but I think we need to recognize what it is, and it is adult court.
Seems a little odd. I want to explore this just a little further. Under your argument, there's a one-year window for the 15 or under to apply. And that just seems to me a little odd, just a one-year period. help me with that. Is there a history? Did it used to be 16 and got moved down to 15? Or, I mean, it just strikes me, I'm repeating myself, but to have a 1-year
Yep.
special provision in the code isn't a position I race to.
Yeah, I think where you go is that originally juvenile jurisdiction was anywhere under the age of 18. And then we had the amendments that said, ooh, you know, we got these 16, 17-year-olds. And I think it was during a time period where we were thinking of these super predator juveniles. So we then made 16, 17, 2 year.
So you're suggesting that maybe pre-existing law was 18 and under, and then they kind of,
And then they
Okay.
went to 16, 17.
and under 18 and under, what was the floor then?
The floor was 14, and it still is. You know, in common law, there used to be this idea that anyone under the age of 14 did not have criminal intent.
That was a presumption, though.
Presumption, yes.
Looking at the big picture, I mean, it seems to me that the way this case is working is kind of consistent with our recent juvenile jurisprudence. I mean, your client didn't go to prison, went to the training school for a number of years. Then there was this very serious look taken at your client as he approached 18. And the judge looked at how he had done at the training school and concluded he's not ready for probation and sentenced him with immediate parole eligibility. And what's wrong with that? It seems to me, if anything, the recent juvenile jurisprudence of this court has cured some of the problems and issues that you're raising.
I think that it's certainly improved, Your Honor. What's wrong with that is partly when you look at how did Noah do at the training school. And, you know, he did really well, really well. And if we're going to look at the juvenile system for the idea that we want the juvenile system to rehabilitate and educate and prepare these kids to go into adulthood, that's what they did with Noah. You know,
Well, again, we can debate how well he did at the training school. I think the father's impact statement at the time of sentencing says that, you know, he really hasn't dealt with the whole issue of murdering his mother in the 4 years. That would give me some pause about whether he's really rehabilitated and really come to grips with the underlying psychological basis under which you kill your mother. And so, you know, I'm just saying, I'm just pushing back a little
No,
bit from
and-
that standpoint that,
and-
yeah, he's made progress and he graduated and, you know, from high school. He did a lot of positive things, but there's also other things that, you know, haven't been addressed yet. And I think that's what the district court indicated in its ruling.
and
At the sentencing, did the judge consider what we've called the Miller or modified Miller factors before pronouncing sentence? Did they have a sentencing hearing and go through what they were supposed to? Do you have any problem with that?
I do have a problem with that, and that is raised in the brief. Upon deciding that the judge was not going to impose a minimum mandatory sentence, no Miller factors were discussed at all. It just said,
Wouldn't the Miller factors be applicable not only to the mandatory minimum, but whether he's going to release him or whether he's going to continue on probation?
I think it informs every decision that the court makes when you look at those Miller factors. And that is why I say that the district court did abuse its discretion in failing to look at those Miller factors. Because if we go back to what Justice Zager was saying, is that, you know, the family feels like Noah hasn't come to terms with what happened. And, you know, that may or may not be true, because the rest of the record shows that the JCO said no matter what explanation Noah would provide his family, it's never going to be good enough. And I think that's understandable. And victim impact statements should be allowed for people to express those feelings, but that's not what necessarily the court is looking at. When you look at the fact that Noah was on the top level for years at the training school, and you look at Dr. Augsburger's psychological assessment, psychiatric assessment of him, he found no mental abnormalities. And if Noah was able to hide it under that close supervision, Dr. Augsburger would be very surprised. He's not saying it couldn't have happened because, you know, maybe it can happen, but he was very surprised.
How does the 2016 amendments factor into the analysis?
I think it's really difficult to look at the 2016 to understand really how it does. You know, the explanation says it limits the jurisdiction. So maybe the legislature said, oh, maybe we need some of those younger kids to be able to go, and maybe 12 is a good cutoff age. You know, it's really not birth. But it's also possible that they looked around and said, everybody's saying, wait a minute, what does this statute mean? Because, you know, this court doesn't have the benefit of other appellate decisions, because I think Noah's case may be the first one. It's really difficult to be able to say what that actually means as far as how it changes. It's possible that the legislature said, 14's not low enough, so we want to change that. Maybe different legislators had different ideas. I don't think we really have a good
How are
answer.
you urging us to apply or interpret it?
Which one, the
2016.
I would say that it shows a couple things. One, as far as changing the age limit, I don't think it shows what the age limit was in the 2011 or the 1995. I am past my time, may I finish? But I think it does show the equalization of sentencing, that the legislature recognized that they didn't have the same type of sentencing options for youthful offender, adult youthful offender, and adults. Thank you very much.
Ms. Lucey, thank you as well. Ms. Chambers.
May it please the court? I'd like to just back up a minute and take a little broader view of this issue. What the defendant is attempting to do is to really shoehorn what would be an unsuccessful disproportionality challenge or an unsuccessful fundamental due process challenge into the framework of a categorical challenge. I'm not aware of any case in the country where a categorical challenge has been permitted where it's not a specific crime with a specific penalty at issue, but an issue of a waiver that applies to all crimes with a whole range of possible dispositions. That's really just not what categorical challenges are aimed at. Having said that, I think there's also probably a consensus that a waiver is not even punishment. And if it is punishment, surely it's not cruel and unusual punishment. Again, taking a step back a little bit, a youthful offender who is waived has all the same, until he turns 18, is treated exactly the same as a child who is not waived. He has all the same dispositional options, including home placement, if the court were to find that appropriate. Obviously, in a case like this, that's not going to be an option, but remember that youthful offender waivers can apply to everything from minor offenses to first-degree murder. So until the child is 18, everything is the same. And only upon his 18th birthday does that child become exposed to other penalties.
Would you help me with the statute, 15 years of age or younger? You've heard my questions of opposing counsel. She says, among other things, well, under your interpretation, it could be any age, down to birth, I guess. I take it that seems to be true, and that seems to be a bit odd as well. It is also true, as she points out, that when it says 14 or older, there's no ceiling in the statute either. So you understand what the issues are. Yeah, explore it with me.
Frankly, I struggle to see how it's ambiguous. In I think 1978, the legislature added the waiver provisions.
When was it?
I think it was in 1978 that the original waiver started. And then in 1997, they added the youthful offender waiver. It doesn't contain a floor because the floor is provided by other things. The child has to be old enough to form mens rea, has to be old enough that a prosecutor would choose to file a charge. There are other things that control the floor, and the legislature wisely chose not to get into that issue. But frankly, the younger the offender, the more likely you are to want a youthful offender waiver as opposed to a waiver for adult prosecution. And the district court is given complete, or the juvenile court rather, is given complete discretion to consider that age and deciding whether to waive or not. So it makes perfect sense to me that there's not a floor. It also makes sense that the legislature decided that 15 and above can be waived for adult prosecution, and 15 and below can be waived for prosecution as a youthful offender. 15-year-olds are the swing group. They're the group where the legislature says, they're 3 years from being adults. Some of those might be okay for juvenile court, some not. That seems clear and reasonable to me, frankly.
Could you address the question whether the Miller factors were applied or should have been applied at around his 18th birthday?
Sure. The Miller factors were not applied. They discussed that at the hearing, and the district court found that he didn't have to apply those because no minimum sentence was being contemplated. The state didn't ask for a minimum sentence, and the court announced that he would not impose a minimum sentence before the start of the.
But there were other minimum sentences available, like release.
There were, but I
or
think
probation.
in props, this court said that where no minimum sentence is at stake, the Miller factors are not applicable. And certainly that's consistent with the purpose behind the Miller-Lyle factors, because those are intended to determine whether some sort of fixed sentence is required. Where there is none, they simply don't apply. That would be an extension, certainly, of the case law, and I think it wouldn't overrule props, but it would certainly limit props in a way that opinion didn't contemplate.
It's still a very individualized hearing, wasn't it?
It was very individualized, yes.
Here's what's interesting, I'm sorry, here's what's interesting about the hearing, to me. A lot of things are interesting about it, actually. But the judge had obviously, read Miller and kind of understood Miller, and even, it seemed to me, showed some awareness of the kind of evolving juvenile justice law. And as you emphasize in your brief, the judge's view was, we're not 100% sure that we've got rehabilitation. He even characterized the prison term as having benefit to the offender. And it seems to me this dichotomy between the juvenile justice system and the prison system, may not be as stark. The district court thought the prison term, again, would have benefit, meaning there'd be rehabilitation, continued rehabilitation services in prison, and presumably a meaningful opportunity to obtain release. But how do we know that's the case? For example, it might look like cruel and unusual punishment, or more like cruel and unusual punishment, if somebody was incarcerated and got no services, just mixed in with the adult population, and we forgot about them. On the other hand, what the judge maybe is expecting is, services, there's going to be a continuum of services. We're going to keep on working with, his issues, and then we'll have a reasonable opportunity to take another look a few years down the line. But we don't have a lot of assurance about that process happening. In fact, there's no assurance. Now, maybe it's a burden of proof issue, but I think you see where I'm going.
I do.
Yeah.
That issue exists, though, whether he's continued under juvenile court jurisdiction or sentenced as an adult. We don't have any assurances that there'll be actual rehabilitation and treatment in juvenile court either. We trust and hope that there will be, and certainly we expect that to happen. We expect that to happen in the adult system as well. We have no more control in one system than
But
we
the
do in
juvenile
the
court
other.
system is at least, I think it's a little different. The juvenile court system is kind of designed to provide services. It's a services ethos. I don't think the same can quite be said to our prison system generally. It used to be rehabilitation and so forth, and because of, resource limitations and maybe changing law enforcement philosophy or whatever, it has tended to be now more incapacitation, I would say. It just, I saw aspects of the district court decision that seemed to want to, he was kind of wanting to extend the period of services and support.
Oh, he clearly did, yes.
And it kind of extend that for a longer period of time, which makes sense if it happens.
Clearly, time was the essence of the court's ruling. He simply looked at Noah Crooks and said, I just don't feel comfortable that there's been enough time to rehabilitate you. And I'm not sure that 5 years is going to be enough time to rehabilitate you. So I'm going to pick the option that gives us the most flexibility in terms of time. We cannot control what happens in the Department of Corrections. What services will be provided, we don't necessarily know.
Let me put it to you this way, it may be, and there's literature that says this, so don't pin me down to it, but there's some literature that suggests that if an offender like this does not get services and does not have a meaningful opportunity for release, that is cruel and unusual punishment.
He does have an opportunity to relief. He's immediately eligible for parole.
Well, yeah, right, but what's a meaningful opportunity?
And
I
I
mean,
don't think we can presume that he isn't going to get services. He clearly will get services.
But this had a sexual connotation to it.
It did.
And we know that they don't give SOTP. We had that case, I think last month or this month, somewhere in there, that we're wrestling with right now until way into the term. So realistically, this kid may never get the SOTP, so he never may be eligible for parole.
They don't do SOTP until you approach your discharge date. So where there's a mandatory minimum, that may not happen for some time. Noah Crooks has an immediate discharge date. So he is eligible and will be addressed immediately.
Are you telling me if you're eligible for parole, they'll do SOTP immediately? That's not what the evidence was in the other case.
Because all those cases had minimum sentences. They wait until you approach your discharge date. So they're not giving you SOTP immediately when you arrive if you have a 21-year minimum sentence. They wait till you're close to being released. But because Noah could be released at any time, I'm not saying the second he gets there, he probably got treatment, but he will be treated quickly.
And isn't that consistent with our jurisprudence now, where we say we can't have any mandatory minimum sentences? We simply rely upon the Board of Parole to make those decisions to determine when they're eligible and when they've reached that level of rehabilitation that would allow them to be released. Isn't that what our jurisprudence says now?
It is exactly what the court has said, is that is the eligibility for immediate or for parole is what cures
But
any concern with categorical unconstitutionality.
The next case is, the DOC is not providing because of financial things. Where does that leave us?
Sorry, the DOT is not providing.
The Department of Corrections is not providing it because of financial things. So where does that leave us? I could see that one coming down the pike.
So can I. The problem is, we're really right now, I think, making more of a gross disproportionality analysis. Under categorical, we just say, what are the options and do those comply with the Constitution? If we are looking at every individual case and seeing exactly what services are being provided, that is not a categorical challenge. And that's what's being made in this case.
Should the Lyle factors be applied on the question of whether to release on probation or incarcerate? And would that lead to a more informed decision for a youthful offender?
It's a little bit hard to see how those work in that context. And let's just take this case as an example. Well, first of all, none of those factors would have aided Mr. Crooks. He came from an upper middle class family, no substance abuse, no physical abuse, no emotional abuse, no sexual abuse. He was attending high school, getting decent grades. He had a stable family, even had contact with a supportive extended family. None of the Lyle factors would have actually helped Mr. Crooks. But even if they would, to help the court predict what's going to happen down the line. And in these cases, we're already down the line. We've already reached the point of adulthood. We've already reached the point where this court has recognized, while maybe not completely developed on a mental level, there's substantial development there, and we can just we can decide at 18. And so that's what happened here. He was almost 18, and the court already had the benefit of that time to see if he could be rehabilitated.
But what seems to have happened, I'm sorry to come back to it, but it's kind of blended. What seems to have happened is the district court said, I'm not ready to say right now.
Mm-hmm.
I mean, there was obviously some evidence pro Crooks and some evidence the other way. And the district court seems to be saying a little bit, time out. And among the Lyle factors is the fact that personalities aren't entirely formed until mid-20s or whatever, and the district court saying we don't quite have enough information. In some ways, maybe part of the Miller factor kind of supports the view of an extended period of observation. But one still wonders whether what the judge is seeking to accomplish will actually happen in the prison setting.
That has nothing to do with the Lyle factors, however. I mean, I understand the court's concern. Those are legislative and executive decisions that we simply cannot control. We
Well,
can-
maybe, but if this guy was getting thrown into the dungeon, we'd probably say it was cruel and unusual punishment. You know, the record doesn't show that. In fact, the record doesn't show really anything as to what's gonna happen.
Right, and that's why we
I would
really
say.
can't make any predictions about that. We'd be speculating, and there's nothing in the record that would support any kind of decision on that basis.
What bearing do the 2016 statutory amendments have on our analysis?
On the amendment to the waiver statute itself,
Yeah.
I think it clarifies, well, the note that came with it said that it was limiting jurisdiction for waiver as a youthful offender. I think that supports the state's position that the 2011 version didn't have a floor. So they added one in 2016 and made it more specific. Other than that, I don't think it has much bearing, yeah. I think it just kind of supports the original, the state's interpretation. I want to go back to the Lyle factors, though. Also, in Lyle, again, because they're contemplating whether a minimum can be imposed, those factors are intended to say, is this a child where we can predict whether a minimum sentence will be necessary, or in the U.S. Supreme Court cases, a life sentence would be necessary. And that, again, isn't relevant to this decision because there's no minimum being imposed. So I think under props, it's really clear that as long as Mr. Crooks was immediately eligible for parole, and he was, there just cannot be a categorical cruel and unusual punishment. Unless there are other questions, I'll stand on my brief.
Thank you, Ms. Chambers. Rebuttal?
Thank you, Your Honor. I think the question regarding whether the district court was saying, oh, maybe Noah's just not ready for release, he admits that he's maybe needs some other services, plays into another issue I raised, whether the district court abused its discretion for failing to recognize that it had discretion other than street probation or prison. With a deferred sentence, a suspended sentence, Noah could have been ordered to the residential facility. Residential facility could have continued to do transitional planning. I think this court is well aware that transitional planning is a very, very big topic in juvenile court. What is going to happen when these children turn 18? Are we preparing them to function in the adult world? DOC has some reentry programs, but certainly not the same level as what a traditional transitional planning could do for a child like Noah.
But the district court did, in fact, specifically reference probation and his consideration of probation as part of his colloquy when he entered the sentence in this matter, didn't he? So it's not an abuse of discretion because he didn't consider all these things.
The first reference was street probation. My choices are street probation or prison. And then when he went on, he talked about probation. You know, as you know, Your Honor, when we start talking about things when we're you know, in the courtroom or whatever, there is a shorthand for things. He'd already said street probation. He didn't say it.
This is a very experienced trial judge who I would think knew what the various options would be available under probation, right?
You would think so, but when you look at this statute, this is a different statute than what, you know, you look at with normal probationary options as far as, you know, adult court. Because the statute is written in such a way that it says, you know, we're going to continue the youthful offender. Well, that's a deferred sentence. Well, then you have to go to the deferred sentence to say what options there are, the corrections continuum, all of those things.
But regardless, it would end in 5 years, right?
Correct.
But what would
Yeah.
happen? So what would happen if in the course of the 5 years he basically failed, let's just say, or he was in some setting and it was just working out unsatisfactory, what happens?
He would have a probation revocation and he would be sentenced to the 50 years if that were to happen. Same thing with anything else. I mean, for a felony probation, minimum 2 years, maximum 5. So that 5 years is really not that much different than what we have in the adult
I
system.
mean, but it's conceivable that someone's not rehabilitated without committing an offense that is worthy of revoking probation, right?
I think when you look at being under supervision for 5 years as he matures, what more does the court want? If he has continued to be law-abiding, I'm not sure what more you're going to get. Either you're going to be successful or you're not. And if you're successful, then the goals have been reached, other than retribution. And so, I mean, are we looking at rehabilitation or are we looking at incapacitation and retribution?
Is props controlling on the question of the inapplicability of the Miller-Lyle factors when there's no mandatory minimum?
You know, I'm racking my brain about props, and I know that, because it wasn't cited, and so I didn't read it again yesterday. But I think props was the one that says the illegal sentence is not a directly appealable. And wasn't props also about the fact that it's a forcible felony and you have to go to prison versus the minimum?
Correct.
Okay. And so I'm not sure that the court really addressed the idea of how these factors inform other decisions versus, you know, the decision of probation or prison. So I'm not sure props is totally controlling, and if it is, I would suggest that you revisit, especially in situations where you have a kid like this.
Well, at least one of the Miller factors maybe cuts against you, it seems to me. I explored that a little bit with the state's counsel, but, you know, all throughout the juvenile justice reconsideration, if you will, has been the notion of plastic development of youth, and that we don't know character until 25, and that we have to wait and see. And of course, your client is 18. So some of the science and some of the Miller type considerations suggest that, well, maybe we should wait until we have a more fully formed character before we decide what to do.
And I think that's true, but I'm not sure that Noah's any different than any other kid, because you have a kid who commits a crime at 17. By the time he's sentenced, he's 18. Well,
Well, but
here,
you have-
Noah wasn't even 18 yet at the time he was sentenced. It happened before his 18th birthday, but I think it's the same thing.
You had 3 experts testify, wide variety. Dr. Taylor, of course, testified as he does. Your Augsburger testified, a wide range, frankly. So isn't a wait and see kind of consistent with the thrust of Miller and Roper and Lyle and all of our cases?
I think that, and I have a couple things. One, none of the doctors testified. They were all reports. Salter and Taylor, those were old reports. They were not even updated reports. So they were from the time that he was 13. Augsburger was the only one that had an updated view of him. And I'm way over my time. May I continue?
You may sum up.
And I think the other thing is that it's natural for this wait and see, but should the wait and see be in prison, or should it be some other thing where he can actually get transitioning? Thank you very much.
Ms. Lucey, thank you as well. The case of State versus Crooks is now then submitted, and we'll next hear the arguments in Lee versus State.